worried that we stay here overnight. We will, of course, before the close of business today, have all council receive a soft copy. It will email, you expect the email. But before I go into my summary business, I need to read the judgment of Lady Justice Fred Mwanga, who retired and left the services of the Judicial in July last year. Because she left, she perused the draft judgment of the Chief Justice and was in total agreement. So I'm reading her concurring judgment, then I go into mine. So this is judgment of Fred Mwanga, Justice of the Supreme Court. I have had the benefit of reading the draft, the judgment of my learned brother, Owindoro CPA. I concur with the analysis and the decision made. I also concur with the proposed orders as embodied in this lead judgment. I have nothing useful to add. Signed by Lady Justice Fred. So this is the summary of my judgments. Even here, I will read everything, and I'll read the core part of the summarized judgment. So the summary of the judgment of Owindoro CPA. It's not a Winnie. Introduction. This appeal arises out of a petition instituted under Article 137, Clause 1 and 3 in the Constitutional Court. In essence, the appeal and cross-appeal are against the majority decision of the learned justices of the Constitutional Court regarding the competence of the military courts, their ability to render fair hearing, offences triable in military courts, and persons subject to the jurisdiction of the military courts in Uganda. The background. When he filed constitutional petition number 45 of 2016 in the Constitutional Court, the respondent was a civilian and member of parliament representing the people of Makawa Municipality, Kampala Capital City Authority, KAIJA, in the 10th Parliament, and shadow minister for KCCA. He filed the petition against the backdrop of events following his arrest, where he was arraigned before the General Court Martial, GCM, and charged along with others with offences under the Uganda People's Defence Force UPDF Act. To wit, offences related to security, contrary to Section 130, subsection 1, paragraph F, with the particulars thereof being that he contrived to plot with others to overthrow the government of Uganda. And treachery, contrary to Section 129A, with the particulars thereof being that he infiltrated the UPDF or was an agent of a foreign power or any force engaging in war or warlike activities against the government of Uganda. He objected to his trial in the GCM, contending that he was not subject to military law as he had no military connection, and that the GCM was not a competent court under the Constitution to try any of the offences with which he was charged. That the GCM overruled his objection. He filed a petition in the Constitutional Court challenging the provisions of the UPDF Act number 7 of 2005, which he singled out in the petition, and acts of the UPDF of arresting, detaining, and remanding him to prison in relation to the charges against him, as being inconsistent with the Constitution. The proceedings in the GCM against the respondent were stayed by an order of the Constitutional Court. He prayed for a permanent injunction to restrain the appellant from continuing those proceedings. The Constitutional Court partly allowed the appeal in its majority decision, where it inter alia held that as a civilian, the respondent was not subject to military law and could only be lawfully tried by a military court if he were charged under Section 119, subsection 1, paragraph G of the UPDF Act, as an accomplice to a principal who was subject to military law. And the principal was so named in the charge sheet. There being no principal named in the charge sheet, the court held that the charges brought against him were null and void and of no effect. The court also declared Section 119(1)H of the Act, which allowed military courts to try persons for offences provided for under other laws outside the scope of the UPDF Act Unconstitutional. According to the court, Parliament never intended that the UPDF Act should be an act of general application, since it is a statute of special and limited application. Hence, the unlimited and regional jurisdiction of the GCM referred to in the UPDF Act only apply to offences under the Act. Last, the court examined the nature of the military courts and held that first, military courts lack all the tenets of an ordinary court established under Chapter 8 of the Constitution, particularly under Article 28(1). Second, they are tribunals, and third, they are not part of the judiciary. The court accordingly ordered the petitioner to be released forthwith. The appellant was dissatisfied with the decision of the Constitutional Court, hence it appealed to this court. The respondent, for his part, cross appealed against the decision, allowing civilians in certain cases to be tried in the military courts. The grounds of appeal are: 1, the learned majority justice of the Constitutional Court erred in law in finding that sections 2 and 179 of the UPDF Act are in contravention of Articles 28(1) and 44C of the 1995 Constitution, and that the GCM is only competent to try military disciplinary offences under Part 6 of the UPDF Act. 2, the learned majority justice of the Constitutional Court erred in law and fact in determining that the GCM cannot be impartial or independent. Is inconsistent with Article 28(1) of the 1995 Constitution of Uganda and does not apply the principles therein to persons subject to military law. 3, the learned majority justices of the Constitutional Court erred in law and fact in determining that charging and arraigning the petitioner before the GCM was inconsistent with Article 28(1) and 44C of the Constitution. 4, the learned majority justices of the Constitutional Court erred in law in finding that Section 119(1)H of the UPDF Act is inconsistent with Article 28(1) and 44C of the Constitution. The appellant prayed that the appeal be allowed. The decisions of the learned majority justices of the Constitutional Court cited this aside, and the appellant be awarded cost of the appeal. The cross appeal. The respondent cross appealed on the following one ground: that the learned majority justices of the Constitutional Court erred in law in holding that a civilian can be charged before military courts as an accomplice together with the person subject to military law. He thus prayed that the cross appeal be allowed, and part of the decision of the majority justices that he has impugned be set aside or reversed. Consideration and determination of the appeal by this court. The appeal first came up for hearing in this court in 2022. From that time to its final disposal today, it has suffered an unprecedented affliction by a host of adversities. There is thus an imperative need to clarify on what transpired within that period. The grave and persistent series of events that characterized the lifespan of this appeal began with the fire that in the chambers of the Chief Justice on the Supreme Court building at Cololo on the 27th April 2022, followed by water flooding parts of the building. This resulted in a condemnation of the Cololo Supreme Court building as being unfit for occupation, thereby leaving the justices of the court with no office accommodation. Thereafter, two justices of the court, namely Justice Paul Mugamba and Justice Ezekiel Mwanguzi, who were part of the original panel for this appeal, retired. This therefore necessitated a reconstitution of the panel. In November 2022, the court was able to secure a temporary home and more justices were appointed to the court. The court then embarked on the process of reconstitution of the panel with a view to sitting by December that year to hear the appeal. However, that December, we suffered the devastating demise of Honorable Justice Ruby Awere Opio, who had been on the regional panel for this appeal. This necessitated awaiting the appointment of additional justices in this court for the requisite reconstitution of the quorum to take place. However, in only 6 months thereafter, yet another tragedy struck this court with the demise of Justice Stella Arach Amoko in June 2023. It was until January 2024 when 2 more justices were appointed to the Supreme Court, whereafter the court was able to reconstitute the panel for this appeal. The appeal came up before the reconstituted panel on 13th May 2024 in the new Supreme Court building at the Judicial headquarters, upon which the learned justices reserved judgments to be delivered on notice. Notice has been served on the parties for delivery of the judgment today, and that's why you are here. So, the delay in this case did not take 4 years, as some people, including members of the learned profession, have dishonestly been feeding the public. The indictment in this case delayed by 8 months, from May last year to today. If you did some arithmetic at school, you'll find this is 8 months, not 4 years. But let me say this also. This is a court of law, court of judicature. The court does not belong to the Chief Justice, does not belong to the justices and judges of the various courts of judicature. It belongs to all of us. It's our property. It belongs to you and me. If you're part of those who bring politics, come to play their politics in this court, you're fighting yourself. You're piercing your own eyes with your fingers, with your nails. Because for as long as you live, you leave this court. The court you're trying to delegitimize, the court you're throwing mud on, is the one you run to. That's not to say courts, judicial officers should not be criticized. As a matter of fact, if people do not criticize you, mean you're doing nothing, and they ignore you. Criticism makes the best out of a person. But please, what you can do in the political field, and some of us have been there, should be different. Whether you're a lay person or you masquerade as a lawyer, please, this is your home. And for many of you, this is your marketplace. Let us use constructive criticism. Let us engage with the Chief Justice, with the judicial officers, with the administration of the judiciary, so we have a better institution. Each time we improve on it, because this is like a hospital. At some day you must go to a medical center. So you will come here, your relatives will come here, anyone who seeks justice will come here. So if your purpose is to destroy the judiciary as an institution, it's like democracy. You may not know the worth of democracy until it is taken away from you. It's like the oxygen, the air we breathe. Many times we take air for granted until somebody closes your nose, then you know how important the air which we take for granted is. So my appeal is, speaking for myself and then on behalf of judicial officers, criticize me every day, walk to my chambers and say, Mr. Chief Justice, how can this be? Write to me, because it's not my property. It belongs to all of us. But this idea of thinking that you can gain fame, you want to be known, you learn how to write in social media, thinking you are attacking the Chief Justice, you are attacking yourself. And I ask all these people, please read A Man for All Seasons. You are cutting that forest which you'll need when the devil begins chasing you. So I thought I should say this and then read my guidelines. But also let me add, let nobody go fearing that, oh, I have stepped on the foot of the Chief Justice, now he's going to bear ill will against me. No. We as judicial officers, we have taken the type of oath you have not taken. We've taken the oath never to fear, including never to fear criticism, never to favor, never to be driven by affection, and most importantly, in the circumstance of this case, never to bear ill will against even those who have thrown mud at us. Because that is the beauty of being a judge. Meaning, that if I can sum up that oath, we must be guided by our conscience. That's really what it is saying. So if you step on my toe, don't fear me. Come to me tomorrow, come to my home. I bear no ill will, and none of the judicial officers bears any ill will. But I also hope that you have the courage to say sorry. Some of the things that have come out of members of the learned profession, unthinkable. So you have to say sorry. Yes, you don't have to say it to me. But some of my judicial officers, please say sorry to them. Because they are doing this for you. The power comes to you. It comes to us from you. Because you're part of the people of Uganda. So having said that, to my consideration of the merit of this appeal, this court has been called upon to clarify the constitutionality of several aspects of the law concerning military trials. Even if the arguments gravitate around trials in the general court martial, the points raised radiate to the whole military court system. I note that the 4 grounds of appeal and the one in the cross appeal raise cross-cutting issues. And this explains why some submissions by counsel on a particular ground were as well reiterated in other grounds. All the grounds contained an element of counter to the challenge raised against the competence of the general court martial and know its status as a court of law. Whereas the standing of the general court martial as a court of law was not raised as a separate ground of this appeal, and yet it was a separate question for determination in the Constitutional Court, upon which the court rendered a decision declaring them to be tribunals. It was implicit in all the grounds of appeal that it was an issue. In determining this appeal, therefore, I adopt an integrated approach where a ground may be disposed of in the course of considering another ground. For instance, the status of the general court martial as a court has a bearing on the resolution of grounds 3 and 4, which entail the determination of the issues of personal and subject matter jurisdiction of the court respectively. During the period after hearing this appeal, the laws of Uganda were revised. The UPDF Act is now cited as the UPDF Act, Chapter 330, while the impugned sections 2, 119(1), H and G, and 179 have changed to sections 1, 1, 117G and H, and 177 respectively. However, there is no change in the content. In this appeal, I consider that the issue of the establishment of a court of law, its subject matter or personal jurisdiction, its structure and the fairness of its procedures, and the exercise of judicial power are distinct questions. In that regard, the specific issues for this court to resolve, arising out of the Constitutional Court decision, the grounds of appeal and cross-appeal are: 1. Whether the courts martial are courts of law duly established under the Constitution or are tribunals. 2. Whether the courts martial can be or are independent and impartial within the meaning of Article 28(1) of the Constitution. 3. Whether civilians can legally, that is without offending the Constitution, be liable to face trial in the courts martial for disciplinary offences, hereinafter called military, disciplinary, or service offences, stipulated in Part 6 of the UPDF Act. 4. Whether civilians can constitutionally or legally be tried in the courts martial for civil offences not comprised in Part 6 of the UPDF Act, but are instead provided for in other legislations. 5. Whether it is constitutional for persons subject to military law to be tried in the courts martial for offences outside the UPDF Act, hereinafter called civil offences. 6. Whether it is constitutional for civilians to be tried by the courts martial as principals for offences under Section 119(1)(h) of the UPDF Act, yet these also exist as civilian offences. This court is aware of the rules of constitutional interpretation and has set them out in detail. You'll find I've set them out in the main judgment. It's a detailed coverage. Counsel for both parties have, in support of their cases, cited several Ugandan authorities. These include Second Lieutenant One Ambrose, Abin Attorney General, Sergeant Paul Kalembera against Attorney General, and others. Other relevant authorities that have also been delivered since the hearing of this appeal, and upon which counsel in this petition have had no opportunity to submit on, are retired Captain Amon Biarugaba and 169 others. The Second Lieutenant One Ambrose of Uganda, this is another decision for the lieutenants. It that falls on this court to ensure certainty in the application of the law by clearly spelling out the principles that should guide on how to structure and how handle matters concerning discipline in the UPDF. This will ensure that the provisions of Article 209 of the Constitution are given effect to, without affecting other provisions of the Constitution. It will also ensure that the enforcement of the provisions of Chapter 4 of this Constitution. Ground 1 is the General Court Martial lawfully established as a court of law. Under Part 8, titled Military Courts, the UPDF Act provides for the Summary Trial Authority, STA, Unit Disciplinary Committees, UDC, and Courts Martial. From the outset, it is clear that the STA and UDC are not established as courts, but as tribunals. The Courts Martial, established at the Division Court Martial, established under Section 196, which is now 192, the General Courts Martial under Section 197, which is now 195, and the Court Martial Appeal Court, established under Section 199, which is now 197, and the Field Court Martial under Section 200, now 198. It is clear that the long title provides that the Act is passed under Article 210 and not 129(1)(b). However, I do not consider that failure to indicate Article 129 instead of 210 as was done in the long title of the UPDF Act alone, is enough to take away Parliament's power given to create a court under Article 129 1B. The General Court Martial is part of the courts of judicature referred to under Chapter 8, albeit with a special limited jurisdiction. The other argument for consideration is whether the creation of the court under Article 129 1B requires an amendment of the Constitution and not a referendum. Under Article 259 of the Constitution, an amendment of the Constitution can only be done by an Act of Parliament whose sole purpose is the amendment of the Constitution and pursuant to the requisite parliamentary procedure for such amendment. I have duly given consideration to the provisions cited, Article 129 that establishes the Court of Judicature, Article 128 that provides for the independence of the judiciary, and Articles 259 and 260 do not stipulate that the creation of a subordinate court per se requires an amendment of the Constitution. Article 129 merely lists the courts of record and provides that the creation of other subordinate courts shall be as established by laws made by Parliament. The UPDF Act is one of those laws, and Section 197.1, now 195.1 thereof, establishes the GCM. It is also evident that the Constitution contemplates the existence of courts martial. See, for instance, Article 2572A and Article 203B of the Constitution. It was contemplated that owing to the unique nature of military work matters or military discipline should be handled by special courts, court-martials in bracket, and military tribunals, UDCs, and STAs. The issue whether the General Court Martial is a court was conclusively settled in Attorney General against Judicial and Attorney General against Uganda Law Society. It would, however, do well if Parliament clearly stipulates in the law enacted the status of a court created as the Magistrates Court Act does. I note that in Attorney General against Mushabe, this court came to the conclusion that since the GCM exercised judicial power, it is or must be deemed to be a court. On the contrary, my finding is that the legality of the establishment of the General Court Martial, not based on this exercise of judicial power, but on the authority conferred on Parliament under Article 129 1D of the Constitution. Exercise of judicial power and tribunals. Before I take leave of this issue, I would like to address myself to the aspect of the exercise of judicial power by courts and military tribunals, on which justices of appeal base their decision in retired Captain Amon Diarogaba. As a general rule, in a democratic society or dispensation, every aspect of judicial power must be exercised by a competent authority established by law. Judicial power, which is exercised by the judicial arm of government as an institution, as is provided for in the Constitution, refers to the authority vested in the courts of judicature, whose judicial officers interpret and apply the law, resolve disputes, and administer justice generally. In a narrower sense, judicial power generally uniquely involves an exercise of power to interfere with the personal liberty of persons who appear before it. And this usually falls exclusively within the realm of ordinary courts of law, although there is no express bar to criminal exercise of jurisdiction by some tribunals. Tribunals usually exercise quasi-judicial power as opposed to judicial power of the courts. As a characteristic, the moment an entity can hear criminal cases and give custodial sentences or detain its suspect during hearing, the entity exercises judicial power regardless of its title as a court or tribunal. In other words, the exercise of judicial power is not in all cases what differentiates a court from a tribunal. I have noted that under the UPDF Act, the UDCs and SDAs, UDC is Unit Disciplinary Committee in case you have forgotten, and SDA is the Summary Trials Authority, that are established as tribunals have been given jurisdiction to try offenses and sentences that they can impose range from caution to custodial sentence. Pursuant to Articles 23, 126.1 and 129.1 of the Constitution, it is only the courts that are granted a mandate to interfere with personal liberty in the sense of custodial sentences, or any legal detention of a suspect for an extended period of time during a hearing. Therefore, in the Ugandan framework of military courts, it is only the courts martial that are established as courts of law under the Constitution that can properly or legally be said to exercise judicial power when hearing offenses, criminal or disciplinary, with the power to impose custodial sentences and detain suspects. The UDCs and SDAs are tribunals. Hence, whatever judicial powers they exercise are unconstitutional, as they do so without lawful authority. Ground number 2. Every court established under the Constitution must meet the criteria for a fair hearing. Similarly, tribunals entrusted with judicial power have to apply the principles that ensure a fair hearing, and for this, the classification as courts or tribunals bears no relevance. The right to fair hearing is one of the fundamental human rights that are considered an imperative in any trial. See Article 28.1 of the Constitution of Uganda as amended. The UDHR, Article 10 of the UDHR, Article 14, Paragraph 1 of the ICCPR, Article 7 of the African Charter. The guarantees of the right to a fair trial applies to all courts and tribunals, including military and other specialized courts. The principle of equality. Judicial power, even though it is limited in jurisdiction, has been devolved to military courts to be exercised in line with the Constitution, while respecting the fundamental rights and freedoms of individuals appearing before them. It goes without saying, therefore, that all persons, including military personnel or persons subject to military law, are entitled to the non-derogable right to a fair hearing. Although a soldier becomes subject to the military system, he does not cease to be a citizen, and his rights as a citizen remain relevant, albeit in an amended form. But whatever legislation is applicable, it must still be interpreted in light of the supreme law. Can a military court be independent, fair, and impartial? A military court can be independent, fair, and impartial. Thus, trial of a person by court-martial does not per se occasion a violation of the person's right to fair hearing provided for under Article 28.1 of the Constitution. That provision does not specify the composition of procedure adopted by such a court or tribunal, other than listing the procedural safeguards required for a fair hearing. However, as noted earlier, Article 128 of the Constitution also imposes a requirement as to objective independence of the court or tribunals exercising judicial power as a safeguard to a fair hearing. Proof. An individual who challenges the independence of a tribunal need not prove an actual lack of independence. See the case of General Rose. In a particular case, the challenge can touch on the whole structure and procedure of the courts. Similarly, This is an objection to the system of trial within the General Court Martial in its current structure. Test for independence and impartiality. What may be considered to pass the test for independence and impartiality, and thus ensure a fair hearing in military courts, has been a subject of wide consideration and discourse. With regard to independence, Article 128(1) of the Constitution provides that, quote, in the exercise of judicial power, the courts shall be independent and shall not be subject to the control or direction of any person or authority, close quote. Article 128, clauses 2 to 8 are all provisions geared towards ensuring and maintaining this independence. To determine whether the courts martial or the persons manning the courts are independent in the exercise of their judicial powers requires an examination of the laws and procedure under which the courts operate. From this, one can then determine whether a reasonable person familiar with the Constitution, the laws setting up the military courts and their structure would perceive and be satisfied that these courts are independent. Counsel for the appellant emphasized that fairness in the General Court Martial is assured because the members of the General Court Martial take an oath to uphold the Constitution and administer justice. Indeed, it is the norm that judicial officers take an oath to render justice, and this places the duty on the respective judicial officers to exercise the judicial power with independence of mind and impartiality. However, this subjective undertaking of exercise of duty is only truly guaranteed when it operates alongside the objective safeguards that can satisfy a reasonable person that the appearance of partiality is eradicated, and the judicial officer is acting with an independent mind and is insulated from extraneous factors such as an undue influence. Impartiality is determined by the absence of bias, objective or perceived. In this regard, objective impartiality is akin to independence. The test for impartiality is, open quote, whether a reasonable, objective, and informed person acting on the correct facts will reasonably apprehend that the judge has not or will not bring an impartial mind to bear on the adjudication of cases, close quote, see in re an application for recusal of Honorable Justice Alphonse Chigamoy Windolo, Chief Justice, miscellaneous application number 3 of 2021, arising from presidential election petition number 1 of 2021, Chagulani Sentamu Robert against Yoweri Kaguta Museveni, Ibuabura, and 2 others. It is clear that in impartiality, appearances are of importance in order to satisfy the subjective requirement. See also the case of R against Spear and Findlay against UK. In the instant case before this court, the respondent makes no allegation that the members of the tribunal were actually biased. I would therefore cast the issue of independence, impartiality, and impartiality of the members of the court as follows. Whether a fair-minded and informed observer would conclude that the safeguards for a fair hearing in the court martial were adequate to guarantee the independence and impartiality of members of the court martial. What is manifest from an examination of our laws is that, with regard to courts martial, 1, with the exception of the CMAC, Court Martial Appeal Court, there is no legal requirement for a person qualified in law to form part of the quorum. Before I proceed, I want to understand that apart from the Court Martial Appeal Court, the others who sit and carry out judicial function, there's no requirement for them to study law, to be lawyers. So it's like there's no requirement for anyone to go to a theater and operate on a patient and pick pick the Chief Justice of Uganda, give him 12 people, not even all 12 people, he would have been carrying the rank of a corporal in charge of a section, and you place him at the body of DRC to protect Uganda against possible enemies. He has never touched the trigger of a gun in life. He doesn't know map reading. He doesn't know how to win civilians to his side. He did not have the 9 months training that is required, the basic training that makes you be a soldier and get the first rank of private. I think the first rank of recruit. Or you ask any professor from Makerere University and say, look, we're giving you a Boeing 474, you fly it to Addis Ababa. These are not jokes. The importance for professional training to be able to do something. What the importance of professional training to be able. And in this, nobody is saying, even the respondents, when they brought the petition, is not saying Major so-and-so or Colonel so-and-so was biased. He's not saying that. Or that, he's just saying, look, these people are training to be judicial officers. And they try treason, they try all sorts of things. But when the LC courts act, the law that placed the LC court, because they knew that the LCs were not trained in the law, they were not given jurisdiction over criminal matters. Not even turtle chicken, by the way. They were not given jurisdiction. So the first one is legal training. 2, the judge advocate's role is entirely advisory, as he or she does not form part of the court that deliberates on the verdict and sentence. So the judge advocate acts like an assessor whose view does not bind anyone. 3, decisions are by majority opinion of members of the court. The courts are convened and the members are appointed by the High Command or some other authority delegated by the High Command. They are not appointed by an independent institution. The commanding officer of the brigade probably would appoint who sits in the divisional court martial. The courts comprise military men with no differentiation as to whether they are active, about to retire, or have retired. Junior members and a political commissar form part of the quorum. You are a major and probably can sit in the body that carries you. No right of appeal is created to the ordinary courts under the Act. The appeal ends with the court-martial appeal court. The unit disciplinary committees and the summary trials authorities exercise judicial power under the law as they have jurisdiction to pass custodial sentences and thus infringing on the liberty guaranteed under Article 23 of the Constitution. With the benefit of various authorities and instruments enunciating the law on the issue of independence and impartiality of courts martial, I have examined the structure and procedure of the courts martial in Uganda to assess how they fare in this regard. I have found as follows: a legal qualification. Currently, the General Court Martial, Divisional Court Martial, and even the UDCs and STS as tribunals exercising judicial power have no legally qualified personnel on their quorum. Yet their jurisdiction is not limited only to disciplinary breaches, but extends to crimes or offences that are also triable by the civil courts. This includes serious offences that attract carceral sentence of over 6 months and the death penalty as well. These untrained persons can issue decisions on questions of law and fact. Go back to the example I gave. You take me to the theater in Molevo, and we don't know the difference between a kidney and the liver. And I'm fairly educated, as you know. Or put me as a brigade commander. Everybody will flee to the area where there is no security. The decision of the judge advocate in the court, who in any case is not a full member of the court, is merely advisory, as I've said, as it is not binding on the panel. The absence of legally trained personnel in the exercise of judicial power in the general court martial and the other military courts or tribunals is at variance with the situation obtaining in the civil courts. This presents two parallel and contrasting standards in the administration of justice. The civil courts are competent as they meet the standards laid down in the Constitution, while the courts martial function in sharp converse there, and this is inimical to the right to a fair hearing before an independent and impartial court. Hence, it adversely discriminates against persons who appear before the courts martial. The consequence of this is that it renders the functioning of the court martials unconstitutional. The composition of the court by military personnel. This issue gives rise to two distinct questions. First, whether a parallel system of military courts or tribunals staffed by members of the military who are aware of and sensitive to military concerns by its very nature, inconsistent with Articles 28(1) of the Constitution. Second, if the answer to the first question is in the positive, whether that is the end of the matter. However, if it is in the negative, then the next question is whether the general court martial, as constituted at the time the respondent was charged under the UPDF Act and regulations made thereunder, is an independent court for the purpose of Article 28(1). I find that the presence of military personnel as members of the courts martial is not by itself evidence of the court's lack of independence and impartiality. However, when viewed by an objective, reasonable person, there is a difference between active servicemen under the chain of command and former servicemen who are in retirement or about to retire, and are therefore not influenced by any hope for promotions. Active servicemen are under the chain of command and may be influenced through the chain of command. Furthermore, the oath taken by the members of a military court under Rule 27 of the UPDF Rules of Procedure Regulations binds them to the High Command and convener of the military courts. This stands in stark contrast with the judicial oath in the Oaths Act, Chapter 19. This, taken together with the non-inclusion of a legally qualified judge on the panel to rule on legal issues, denies the courts martial the independence and impartiality which would have clothed them with competence. The other judicial oath, you swear to protect the Constitution. In the military, you swear to protect the commander-in-chief, the other officers. That's the difference. That's the difference which comes out. Well, that's the law that Parliament passed in it. C, manner of appointment of its members. There is the military personnel sitting on a tribunal that handles purely disciplinary matters, and only only imposes such punishment as reprimand, demotion, dismissal, compensation on the one hand, and military personnel sitting in the court, which has the competence to try persons for crimes which attract such penalties such as custodial sentence or even the death sentence. I am of the opinion that there is a need to distinguish between the two in determining the issues concerning the court's martial. First, the appointment to the service disciplinary organs is normally limited to administrative matters, whereby the fact of the presiding officers being subject to the chain of command does not occasion any miscarriage of justice. Unlike with the appointment to the courts martial handling substantive judicial matters where it could occasion justice, the appointment of an officer on the courts martial by the President or High Command might not necessarily suffice to deprive the court of the requisite independence for the exercise of judicial power. However, this must be taken together with the provisions for other safeguards for the promotion and guarantee of the independence of the courts martial, and then determine the effect of such appointments on the independence and impartiality of the members of the court. The provisions for the appointment of personnel on courts martial must be in conformity with the provisions for appointments of judicial officers in the civil courts and ensure competent persons sit in all courts. The term of office, that is security of tenure. This relates to the terms of appointment of the members of the court, including the judge advocate. The appointment of members of the courts martial is by the High Command and for a period of 1 year only, though eligible for reappointment. There are also waiting members who are appointed and can be called upon to sit in court as and when needed to realize quorum. See Regulation 21 and 23 of the UPDF Act Rules of Procedure Regulations. The fact that a member of the court is appointed only for a short period of time and on an ad hoc basis means that such a person may have no cushion against external influence by the one who appoints him or convenes the court. They do not have protections of security of tenure available to civil judges in Article 128 of the Constitution. I therefore reach the conclusion that the provisions of the law governing the courts martial do not guarantee their independence or impartiality. E. Convening authority and prosecuting authority. The convening authority performs an important role in the court martial judicial process because the laws grants it the dual role of the court and that of the DPP. Under the powers conferred on it by Regulation 21, this authority, among other things, determines the charges to be preferred, appoints the prosecutor, issues a convening order, determines the time of trial, and procures attendance of the witnesses. It has been held in other jurisdictions, in criminal prosecutions, it is an imperative that the convening authority lies with court, which enjoys guarantee of institutional independence from the body prosecuting cases in court. However, with regard to the courts martial, the situation is wholly different. The military appoints the convener of the court from within its ranks, and similarly does so for the prosecutor of the court. It also appoints officers who are under its command to preside over the court, but accords them no security of tenure in the exercise of their function as members of the court. This situation does not portray or manifest an impartial and independent court. Accordingly then, its constitution and exercise of judicial function is unconstitutional, as it violates Article 28(1) and 44(c) of the Constitution. F. Existence of other guarantees against outside pressures, also known as objective impartiality. Most of the determinants of independence and impartiality of courts have been institutional. The other aspect of fair hearing is the legal procedure available to to a suspect who appears before the GCM. Procedures of fair trial are to be observed by all courts and tribunals that are an integral part of the judicial system. No adherence to a fair hearing has a double-edged effect. The obvious one is the denial of an accused person the right of due process. The other may have an adverse effect on this, as some accused person may also escape punishment under the guise that they were not given fair hearing. Out of the minimum guarantees for fair hearing under Article 28, I only consider two. I find that the courts must do not guarantee the right, adequate time and facilities for the preparation of a defense and to be tried without undue delay. And they also foreclose the right of appeal to ordinary courts. With regard to the right of appeal, there is international consensus that military laws and other legislation should never foreclose the right of appeal from decisions of military courts. A general foreclosure of the right of appeal to ordinary courts, inclusive of convictions for non-capital offences, is by any legal standard unacceptable and is in our jurisdiction clearly unconstitutional. It has recently been held by the Court of Appeal that the right of appeal to the ordinary courts from military courts is unavailable since the UPDF Act does not provide for it. See Muamu's example case. The interpretation that highest appellate court does not refer to the Supreme Court limits the rights of military personnel as compared to civilians in capital cases, in a way that is not justified under Article 43 of the Constitution. Any law where there is no provision for the right of appeal to the Supreme Court for a person who, upon trial and conviction, is liable to suffer the penalty of death is inimical to the right to a fair hearing. Hence, it contravenes Articles 22(1), 21, 28, and 44C of the Constitution. Having regard to what I have discussed above on this issue, in the light of the rights to a fair trial enshrined in our Constitution, I am therefore in full concurrence with the Constitutional Court in this regard, and accordingly, ground 2 would have been free. Ground 3 and the cross appeal. I have already found that the provisions for the military courts do not have the requisite safeguards that will ensure fairness and impartiality in the exercise of their judicial function. I should point out that even if they pass the test for fairness and impartiality, it will still be incumbent on this court to determine whether or not it is constitutional to try civilians in the general court martial or in the military courts or tribunals. The impugned provisions of the UPDF Act provide that only persons subject to military law can be subjected to trial in a court martial for a service offense. The service offense is defined in Section 2 of the Act as, open quote, service offense means an offense under this Act or any other Act for the time being in force committed by a person while subject to military law. Persons subject to military law are listed under the impugned Section 1191 G and H, which is now 1171 G and H of the UPDF Act as follows. G. Every person not otherwise subject to military law who aids or abets the commission of a service offense. H. Every person found in unlawful possession of 1. Arms, ammunition, or equipment ordinarily being the monopoly of the defense forces, or 2. Other classified stores as prescribed. Both paragraphs G and H of Section 119, now 117, of the Act are wide enough to encompass civilians within its purview, read together with Sections 2, now 1, and 170, now 9, now 177 of the Act. A key ingredient for the sustenance of the charge against the suspect as an accomplice is the naming in the charge sheet of a principal alleged to have committed the offense, which the person charged together with the principal allegedly aided or abetted. This is But in failing to name in the charge sheet the principal to whom the respondent was allegedly an accomplice, then that is being charged before the court martial under provision within section 1191H of the UPDF Act unlawful for being defective. However, should it be determined that the military court has no jurisdiction to determine matters involving civilians at all, this finding will be of no effect. The purpose and effect test in principle of constitutional interpretation is vital in determining the constitutionality of legislation. The purpose of the military courts provided for under the Constitution and the UPDF Act is to promote and ensure discipline in the military. Courts martial or tribunals are specialized courts meant to serve the function provided for in Article 209 of the Constitution, for which they require the highest form of discipline. The current effect of trial of civilians in the military courts for criminal offenses is that they will not partake in the rights enjoyed by their civilian counterparts who appear in the civilian courts for the same offenses. This includes the right to a fair hearing, discussing the resolution of Crown 2 under Article 28(1), and as provided for in the international covenants discussed above. Worse still, such persons can face trial for offenses whose trial are within the purview of the ordinary courts, with the military courts having right to impose the death penalty, and yet the law as it stands does not avail the convict the right to appear to the Supreme Court. This limitation on their rights to appear before a civilian court is not justifiable under Article 43 of this Constitution. Military trials should be limited to cases where the state party to the covenant can demonstrate that recourse to such courts is necessary and justified by objective and serious reasons in concreto. I'll explain what in concreto is. That is, to try civilians in a military court, the state must really demonstrate and prove to the satisfaction of court that it is inevitable, it cannot be done otherwise. So, it must be proved that the ordinary courts are not competent to hear the case. That is, civil courts or ordinary courts cannot hear that case. They lack the competence to do so. The other alternative forms of special or high security civilian courts are inadequate for the task. Hence, recourse to military courts is unavoidable or inevitable. C. Referral to military courts guarantees full respect for the rights of the accused and as prescribed by Article 28 of our Constitution. The issues have been discussing this afternoon. The burden of proving the existence of these exceptional circumstances lies with the state. It is therefore incumbent on the appellant to demonstrate that the trial of civilians by the military courts is connected to the purpose in Article 209 and 210 of the Constitution in a way that is justifiable under Article 43 of the Constitution. From the peculiar facts of the instant case, as is discernible from the record of appeal, it is clear that there was no assessment of the individual circumstances apart from the fact that one of the accused was military personnel at the material time. The provisions for the blanket trial of civilians in the military courts, either as principle in Section 1171H or as accomplices in Section 1171G, does not satisfy the limitation requirements of Article 41 of the Constitution. Likewise, the act of the trial of civilians in the civilian military courts under those provisions is unconstitutional. three of the appeal could fail, while the cross appeal succeeds. Grounds 1 and 4, jurisdiction over subject matter. The impugned sections of the UPDF Act under grounds 1 and 4 of the appeal challenge the competence of military courts to try offences under all enactments. Section 2, now 1, taken together with sections 179, now 177, and 119, 1G, now 177, 1B, of that act leads to the concurrent jurisdiction of the military and civilian courts in criminal matters. The question here for the consideration is the constitutionality of this provision. In the light of Articles 28 and 44 of the Constitution, which the respondent contends requires trial of criminal offences in ordinary courts before civil judges, having found that the courts martial should not generally try civilians, I would narrow the issue at hand thus, open quote, should military officers be tried in the courts martial for all civil offences in addition to disciplinary offences? Close. Does their trial in the courts martial for civil offences contravene Articles 28.1 and 44C of the Constitution? Article 28.1 of the Constitution does not expressly bar trial of military personnel in a specialized military court, which meet the criteria discussed in Ground 2. This is because judicial power can properly be given to specialized courts such as the military courts. Does that exception include trial of military personnel for crimes under other enactments? I find the answer to this narrower issue in the determination of the purpose and effect of the impugned provision. I have already held that the maintenance of discipline is a valid purpose. The effect of the impugned provisions of the Act is that all persons subject to military law will face trial in courts that are markedly different from the ones their civilian counterparts are subjected to for the same offense. In light of the non-derogability of Article 28 of the Constitution and the right to equality under Article 21 of the Constitution, I do not find it justifiable to limit the rights of military personnel as such. I therefore find that the impugned Section 2, 179, 1191A of the UPDF Act adversely affect the liberty interest of all persons subject to military law. Offences not triable by the courts martial. There are other vital reasons militating against trial of persons subject to military law for all offences. The court has previously held that there are certain offences that are not triable by the court martial. This is so where a particular act grants jurisdiction under it only to specific court or only with consent of the DPP. It would therefore be wrong for Parliament to cause a conflict by conferring on courts martial jurisdiction to try such an offence or a similar offence. Where an offence attracts the death penalty, a court martial should have no jurisdiction to try it until the right of appeal is created from sentences for offences attracting life imprisonment and death penalty in the courts of record as is available to other persons and provided for by the Constitution. The trial of criminal offences attracting those penalties is unconstitutional for violating Section 28.1, Article 28.1, 44C, 21 and 22 of the Constitution. Effect of subordinate court subject matter. Additionally, as already noted, the General Court Martial and other military courts are all subordinate courts. The Attorney General against Uganda Law Society, Mulanga, Justice of the Supreme Court. However, I do not agree with the finding in the Attorney General of Uganda Law Society that the General Court Martial is subordinate but not lower than the High Court. That is self-defeating, it's contradictory. not lower than the High Court, and enabling it to handle offences as part of the Superior Courts of Record. Assigning the ordinary English meaning to the word subordinate, all courts martial are subordinate courts created under 129(1)(d) can only have jurisdiction that is lower than the High Court. Holding that it is subordinate but not lower than the High Court is contradictory. It actually makes no sense. It's illogical, and has the potential to create an absurdity when it comes to the hearing of capital offences. Should Parliament desire to grant them the jurisdiction to handle capital cases, then it will need to do so in line with the Constitution. With this finding, the hearing by all courts martial of offences within the jurisdiction of the courts of record is unconstitutional under Articles 28(1), 44(c), 128(1), and 129(d). I hereby find Section 1, 177, 117H, 1H of the UPDF Act are unconstitutional insofar as they, without qualification, allow for trial of persons subject to military law for civil offences within the General Court Martial and other military court tribunals. Basing on this analysis and finding, grounds 1 and 4 of the appeal would fail. Upon examining the objective of the law and the authority cited, I find that the impugned provisions of the UPDF Act are overbroad and rationally connected to the broader purpose. The claim in democratic dispensations, especially in the new democracies such as Uganda, which witnessed gross human rights violations in the past and reminds itself of its ugly past in the preamble to the Constitution, a sober decision has to be consciously made. Sections 2, now 1, 170, now 177, and 119(1)H, now 117H, 1H, that allow the trial of persons subject to military law for all offences under other enactments without any qualification is overbroad. The need to maintain discipline is no justification for the trial of members of the UPDF who are within the country by the military courts, and yet there is a functional judiciary. Any disciplinary action on an officer can be effected after a finding of guilt by the ordinary court. I hereby find that sections 2, now 1, 179, now 177, and 119(1)H, now 117(1)H of the UPDF Act are unconstitutional insofar as they, without qualification, allow for trial of persons subject to military law for civil offences within General Court Martial and other military courts tribunals. Based on this analysis, as I've said, grounds 1 and 4 of this appeal would fail. Having made the findings that the provisions of the UPDF Act that confer powers on the military courts to exercise judicial powers are unconstitutional, there arises the consequential issue of the fate of those who, at the time of this decision on unconstitutionality of the UPDF Act, are facing charges or undergoing trial or have been tried and convicted before or by the military courts. This issue was neither raised nor canvassed at the hearing of the appeal. So this court has not had the benefit of counsel's opinion on the matter. Nonetheless, it is a matter of great public interest, hence this court has to deal with it. Issues concerning the extent to which judicial adjudication has a retrospective effect, especially regarding a finding that a law or act is inconsistent with the Constitution, is not novel. See Duke, Mabea, and A against the governor of Upper Hill Prison, whose citations are given. Two rules have been developed, which have gained universal recognition and application. First is that once a law has been declared unconstitutional, then applying the principle of direct review, the declaration has a force of retroactive application. Where, however, the accused person was convicted under a law that is later declared unconstitutional and has either exhausted the appeal or has not pursued any appeal, the matter is taken to have been concluded. In such circumstance, the declaration of unconstitutionality of the law has no retrospective application. In retroactive application of new rules, there is a difference between civil and criminal cases. We are here concerned with the latter. Whether a decision announcing a new rule should be given prospective or retroactive effect should be determined at the time of that decision, as this one here now. Thus, there is a further difference between criminal cases on direct review and those on collateral review. Direct review concerns those criminal cases where the person seeking relief arising from the new rule has not yet been tried, is undergoing trial, has been convicted, but is still pursuing a direct appeal, while collateral review refers to those cases where the criminal defendant has exhausted all direct appeals, if any. I cite the authority responsible. In Uganda, the Constitutional Court in Mabea case and American jurisprudence linked letter case cited, United States Johnson case, Griffith Kentucky case, Stovall Deno case, and the court cited this and came to the conclusion that retrospectivity should depend on one, the purpose of the new rule, two, the extent of reliance on the new rule, and three, the effect on the administration of justice of the retroactive application of the new rule. The decisions following linked letter laid down how this rule would apply to pending cases and those on appeal and direct review. The current American position elucidated in an annotated constitution prepared by Congressional Research Service at the Library of Congress and quoted in A against Governor of Upper Hill Prison, stated as follows, open quote. The court has now drawn a sharp distinction between criminal cases pending on direct review and cases pending on collateral review. For cases on direct review, the new rule for the conduct of criminal prosecution is to be applied retroactively to all cases, state or federal, pending the direct review or not final. Thus, for collateral review in federal courts of the state courts, criminal convictions, the general rule is that new rules of constitutional interpretation announced after the offender's conviction has become final will not be applied. Thus, application for habeas corpus based on a judicial decision subsequent to a conviction becoming final and not otherwise under direct appeal or review fall into the category of collateral review and therefore not entitled to rely on new rules of constitutional interpretation. This principle is apparently not novel to our modern time, as Cicero is credited with having coined the maxim, summum ius summa in iuria, variously translated but classically as the strictest application of law is the greatest injustice. This general principle regarding the effect of declaring a legislation unconstitutional was succinctly stated by Murray J. in A against the Governor of Upper Hill Prison, as follows. In a criminal prosecution, where the state relies in good faith on the statute in force at the time, and the accused does not seek to impugn the bringing of or conduct of the prosecution on any other clause that may be in law, open to him or her, in including the constitutionality of the statute before the case reaches finality on appeal or otherwise, then the final decision in the case must be deemed to be and to remain lawful, notwithstanding any subsequent ruling that the statute or a provision of it is unconstitutional. The learned CJ explained the meaning of a collateral attack as follows. A collateral attack arises where a party, outside the ambit of the original proceeding, seeks to set aside the decision in a case which he has already been finally decided. All legal avenues, including appeal, having been exhausted, for reasons that were not raised in the original proceedings, but for reasons arising from a later court decision on the constitutionality of the statute. He made a comparative survey and review of various jurisdictions on the issue and found commonality in the decision taken by them on it. He then said, the question of retrospectivity in the form raised here is one which is material to all legal systems. The fact is that at no stage during the course of the hearing in this case was the court's attention drawn to any system of justice in which a finding that a law is unconstitutional, even where this is deemed to be so ab initio, meant that previous and final judicial decision based on such a law must inevitably be considered unlawful and of no effect in law. I'm not aware of any legal system to that effect. Referring to the situation obtaining in the US, said there are transcendent considerations which militate against complete or absolute retrospectivity. Fundamental interest of public policy requires limitation on the retroactive effect of judicial decisions. The legal order and the administration of justice is not one perfect symmetry. As Justice Benjamin Cardozo observed at page 161 in his seminal work, The Nature of the Judicial Process, Yale University Press, 1921, we like to picture to ourselves the field of the law as accurately mapped and plotted. We drew our little lines and they hardly down before we blur them. Although judicial adjudications do not have retroactive effect, there are important exceptions and restrictions to that effect. The line must be drawn in the interest of justice. CJ further elucidated on the matter thus. A judgment condemning a statute for being inconsistent with or contrary to the Constitution does not mean that all which was done or decided under the statute prior to the decision on constitutionality is in all circumstances void and of no effect. It is a principle which is, for reasons indicated in the various judicial dicta which are cited, consistent with the Constitution as a whole. The common law dimensions of our legal system and the legal system of many other countries in which the courts have the same or an analogous power of judicial review of the validity of laws. Then they said, certainly issues concerning the constitutionality of statutes are on a plane higher than the mere common law. They concern questions fundamental to the rule of law, the protection of rights, and the very framework within which, in the words of the preamble of the Constitution, true social order is attained. Normally, those fundamental constitutional concepts, such as the rule of law, individual rights, justice, and a social order based on that rule of law, blend together so that the principles of constitutional justice to be applied to resolve issues may be readily deduced. On other occasions, some of those considerations may be competing or even conflicting ones, where the courts have to balance those different interests so as to do justice within the framework of the Constitution. In this instance, one may say in broad terms that there is a competing interest between the claim by the applicant that he stands convicted under a law which has subsequently been found to be inconsistent with the Constitution as from 1937, and the interest of justice, including the rights of the victim, where he was otherwise lawfully convicted of unlawful carnal knowledge of a 15-year-old girl in circumstances where, as his counsel acknowledges, the conviction and sentence were not tainted by any want of fairness or justice. Thus, the effect of absolute retroactivity, for which the applicant argues, in a sense raises competing consideration, which the court has to address having regard to the provisions generally of the Constitution and what Henry J. alluded to as transcendent constitutional consideration, the public interest, the common good, and social order. In response to the argument that the declaration that the law is unconstitutional, the learned CJ had this to say: absolute retroactivity based solely on the notion of an act being void ab initio, so as to render any previous final judicial decision null, would lead the Constitution to have dysfunctional effects in the administration of justice. In the area of civil law, it would cause injustice to those who had accepted and acted upon the finality of the judicial decision. Rights which had become vested in third parties as a consequence of such decision would be put in jeopardy. The application of a principle of absolute retroactivity consequent upon the declaration of unconstitutionality of an act in the field of criminal law would render null and of no effect final verdicts or decisions affected by an act which at the time had been presumed or acknowledged to be constitutional and otherwise had been fairly tried. Such unqualified retroactivity would be a denial of justice to the victims of crime and offend against fundamental and just interests of society. I find it quite persuasive and applicable to the current situation, because the constitutional rules declared touch on the fundamental aspects of a criminal trial in a democratic dispensation. In the present case, we have those who have been charged, those undergoing trial, those convicted and in the process of challenging such conviction, as was the case in the referendum of one case Supra, and those whose conviction is final. This is the situation of the obtaining with regards to those who have been defendants in the courts martial. I consider that the first three categories that fall under direct review and without any difficulty take benefit from the rules expounded herein as regards trial in the courts martial. However, for those whose trial is completed or who are also referred to as those on collateral review, it is my considered opinion that they fall within the exception enunciated above. In the event, I will make the following declarations. 1. Trial Authority, STA, and the Unit Disciplinary Committee, UDC, are respectfully, lawfully established under sections 191 and 192, now 189 and 190, and section 195, now 193, of the UPDF Act as military tribunals. 2. The provision of section 197, now 195, of the UPDF Act establishing the General Court Martial as a competent court is constitutional. 3. The General Court Martial created under section 197, now 195 of the UPDF Act is a subordinate court of law but with specialized jurisdiction. 95.3 and 4, now 193, 3 and 4, read together with section 179, now 177 of the UPDF Act, which grants this STA and the UDC the exercise of judicial power of detention and imprisonment of any person tried by them, contravene Articles 23, 126.1, and 129.1d of the Constitution. Hence, they are unconstitutional. 6. The provisions of the UPDF Act constituting and providing for the trial procedure of the General Court Martial, the Divisional Court Martial, and the Court Martial Appeal Court do not contain any or sufficient constitutional guarantees and safeguards for them to exercise their judicial functions with independence and impartiality, which is a prerequisite for fair hearing provided for under Articles 21, 28.1, 44C, and 128.1 of the Constitution. The provisions of Section 1191G, number 1171G of the UPDF Act, under which the respondent, a civilian, was charged and arraigned in the General Court Martial, contravenes Article 28.1, 44C, and 21 of the Constitution. Hence, it is unconstitutional. The provision of Section 1191G, now 1171G, is unconstitutional to the extent that it permits trial in the courts martial of civilians who have allegedly aided and abetted the commission of a crime, of a service offense rather, or ordinary criminal offense in which a person subject to military law is a principal offender. 9. Sections 2, 179, 119, 1H and G, now respectively sections 1, 177, 117, 1H and G of the UPDF Act are unconstitutional since they confer blanket jurisdiction on courts martial to try civilians. The jurisdiction conferred by Section 2, 179, and 191, 1H, now sections 177, 117, 1H of the UPDF Act on the General Court Martial to try persons subject to military law for civil and non-disciplinary offences committed in Uganda is unconstitutional, as they contravene Articles 209 and 210 of the Constitution. I would accordingly propose the following orders. The declaration of the Constitutional Court that Section 1191G, now 1171G of the UPDF Act, which provides that any person not otherwise subject to military law who aids or abets a person subject to military law in the commission of a service offense is constitutional, is hereby set aside. All charges or ongoing criminal trials or pending trials before the courts martial involving civilians must immediately cease. I'm going to chase you out.
Recording.
This is not cloud 9. I said all charges or ongoing criminal trials or pending trials before the courts martial involving civilians must immediately cease and be transferred to the ordinary courts of law with competent jurisdiction. 3. This judgment, you just nod, don't stop this clapping thing.
I know.
This judgment shall have no retrospective effect on any conviction made and sentences imposed prior to the date of this judgment, save where the conviction and sentence is being challenged in a court of law. All pending trials or partly high criminal cases that fall under the civil law court's jurisdiction, which are against members of the UPDF who are subject to service law, must be transferred to the civil courts with competent jurisdiction. 5. Save for the issue of the establishment of the General Court Martial as a court of law, this appeal fails and is hereby dismissed. The cross appeal is hereby allowed. The respondent is entitled to the cost of this appeal and in the Constitutional Court. I'm going to empty the court and I read the judgment without any of you. Just try me again one more time. Advisory order. This court is giving an advisory order to the executive branch. An advisory order is an advice which is slightly stronger than an ordinary advice. That's why it is called an order. They are not bind, but it will be foolhardiness if you do not pay attention to it. That's really what it is. You may not take it, but at least you give it consideration. That's why in law it's called an advisory order. At times it's called an opinion, but it is an order, not justiciable, but it is nonetheless an order. Court-martial are not unconstitutional merely by their very nature of being military courts. The people of Uganda pronounced themselves in the course of the making of the 1995 Constitution, expressing their fervent desire to make a break from the ugly past that characterized life in our country, especially the grave abuse of human rights by the military. The Ugandan military has since been transformed into a professional force, and it has made remarkable contribution to ensuring regional peace, security, and stability. It is rather contradictory and rather disconcerting for a military force built on new and commendable professional dispensation to operate under the same legal framework that failed to check or avert military abuse of power with unspeakable ramifications. The 1995 Constitution provided the new wine, which the UPDF Act, as instead through the impugned provisions of the Act, sought to store in old wineskins, as it were. This is a blatant negation of the aspirations, desire, hope, and wishes of the people of Uganda, which the framers of the 1995 Constitution meticulously enshrined in no uncertain terms in the Constitution. It is noteworthy that in Uganda Law Society against and Kaija's against the Attorney General, the Constitutional Court observed that the Constitution was unfortunately being ignored and recommended that Parliament could amend the Constitution to provide for any special needs of the military. It said, open quote, the UPDF is currently being operated under laws and practices which still contain colonial relics in total disregard of the Ugandan Constitution. No attention was paid to this problem when drafting the 1995 Constitution. This court has no powers to bend the Constitution in order to accommodate special need, whether legitimate or not, of the army. It is only Parliament that has the power to amend the laws, including the Constitution, to accommodate such special concerns of the army. So far, it has not done so. I must therefore stick to only such interpretation of the law that is consistent with the Constitution as it stands now, close quote. The current military courts operate in violation of the constitutionally enshrined and securely protected rights to a fair hearing that are equally recognized universally in conventions and other instruments. Thus, there is need for a robust legislative intervention to ensure the UPDF Act is in accord with the cherished aspirations of the people of Uganda, as was unmistakably captured in the Docker Commission report. In the full judgment, I actually reproduced so much of that report extensively. It is therefore incumbent on the executive to generate the policy and Parliament to pass the legislation which addresses and cures the injustice occasioned by the unconstitutional provisions of the UPDF Act, which have now been quashed by providing for military courts that are clothed with the constitutional safeguards of independence and impartiality that are accorded to ordinary courts. In recognition of the special nature of the military, legislation must be put in place that establishes and confers on the courts, martial, and tribunals the powers to execute lawful jurisdiction over members of the military, and thus fulfill the function of the UPDF. However, this special exercise of jurisdiction must not infringe on the soldier's right to a fair hearing. The state needs to act in order to ensure that the character of military courts and tribunals meet the democratic standards and aspirations of the people, which are clearly enshrined in the Constitution. It is noteworthy that the court advised in 2009 in Uganda Law Society against Karugaba, that the military courts to be truly independent and impartial, there are desirable changes that the executive needs to address in order to force. In order for this to be applicable to the military courts, the article would have to be modified in such a way as to give the courts independence and impartiality without compromising their military nature. The army would have a parallel judiciary with legally trained soldiers to professionally man the courts. In order to be impartial, the court must have security of tenure and other privileges enjoyed by the other judicial officers in the Ugandan judiciary. It should be noted that the definition of judicial officer contained in Article 151 does not exclude persons exercising judicial power in military courts, close quote. I consider the need for this recommended transformation as relevant today as it was then. In the premises, I would make the following recommendations for consideration by the Executive and Parliament as viable alternatives for the establishment and or creation of military courts in Uganda. These are recommendations. They can pick any, they can reject all, but these are recommendations which the people of Uganda hope to look into. A. Administratively establish the General Court Martial as a division of the High Court without the need to create a new court, with jurisdiction to handle capital criminal cases involving both military officers and any civilians who would exceptionally fall within its ambit, with magistrates within the division handling offences falling under their jurisdiction. B. Limit the functions of the unit disciplinary committees and summary trial authorities to handling strictly disciplinary offences with no power of imposing sentences or imprisonment. C. Utilize the existing magistracy to handle the rest of the criminal cases other than disciplinary offences committed in Uganda, which are currently falling within the docket of the UDCs. The subordinate military courts can handle criminal cases at the level of Chief Magistrate's Court for offences attracting life imprisonment and below. Or D. With the advice of the Judicial Service Commission, appoint civilians with the requisite professional legal qualifications to serve as judicial officers in the current subordinate military courts. They would exercise jurisdiction over offences triable by the subordinate courts. They should have the same privileges and safeguards as their counterparts in the civil courts. Or E. Amend the Constitution to establish superior courts within the military court system under Article 139 and clothe them with the requisite jurisdiction and guarantee of independence and impartiality to strike specific military offences of a capital nature and all other capital offences under existing laws committed by military personnel. Or F. Provide in the UPDF Act for the High Court to sit as a court martial with power to try all criminal capital offences within the High Court jurisdiction, and those unique to the military that attract the maximum of life and death sentences. Grant the Chief Justice powers to assign judges to the military courts. A select number of military personnel can act as assessors. Appeals to the court-martial appeal courts would follow the same format, with the Court of Appeal sitting as such. Magistrates' Court would assume the jurisdiction over all other offences of a subordinate court. G. Make provision in the UPDF Act for trial of civilians in military courts to be only under limited circumstances and only after the state has concretely demonstrated to the court by verifiable facts and by objective and serious reasons the need and justification for recourse to the military court. This must not only apply where, in relation to specific class or category of persons and offences, question, ordinary courts are not in position to undertake such trial. H. Made provision in the UPDF Act for appeal from military courts and tribunals corresponding to appeals in the ordinary courts. In each of the options suggested above, the jurisdiction of UDCS and SDS must be limited to that of tribunals, handling strictly disciplinary offenses with no power of detention or imprisonment, as is the case with other disciplined forces, such as the police and prisons. Dated Kampala, this 31st day of January 2025, Alphonse C. Owindolo, Chief Justice. Now, since my brothers and sisters agree either unanimously or by majority concurrence of the orders proposed in this judgment of the Chief Justice, orders are hereby accordingly given in the terms proposed by the Honorable Chief Justice according to that ratio. Judgment is delivered at Kampala this 31st day of January 2025. As I said, we intend to obey the support of the judgment by close of business today.
My Lord, we thank my Lord the Chief Justice, Justice of the Supreme Court. On behalf of the respondent, we thank this court for this bold decision, and at the same time, as a senior lawyer, we also seek for forgiveness for some lawyers practice and utter issues they do not understand, which tend to undermine the essence of this court. My Lord, we are sorry on behalf of the Uganda Law Society, but otherwise we are so grateful for the bold step this court has taken, and I think we have no way of expressing it. Thank you, my Lord. It's much obliged.
My Lord, for my clients who expected to go to the general court martial.
Who are your clients?
Who were sentenced to 1,000 shillings in the general court martial. They will miss out on paying it.
That's why he's not dressed as a lawyer. He thinks I was going to jail him.
We are only grateful by
You know, this man, one time he invaded me here. When you invaded me with journalists and some stranger, they are going to the Kizza site to see how an irresponsible administration of the city can cause such a misfortune. That's why you did not find me here. I'm going to Kizza.
Jurisdiction of Uganda. Congratulations. I almost wanted to cry. You're
Tumwirute.